Everyone, and welcome to today's webinar, Legal Protections for Immigrant Children Who Are Victims of Human Trafficking. I am Lauren Beal. I'm a Senior Program Manager at the National Council of Juvenile and Family Court Judges. The NCJFCJ is a national nonprofit judicial membership organization, and we provide training and technical assistance to courts around the country on topics related to juvenile and family courts, including best practices in the treatment of survivors of child sex trafficking in courts and the resources available to children who survive sex trafficking. During this 90-minute webinar, we will be discussing the legal protections of immigrant children who survive sex trafficking. For many immigrant youth who survive sex trafficking, obtaining access to immigration relief, such as visas, can be an off-ramp that assists young people in successfully and safely being freed from sex trafficking. Juvenile and family courts have the unique power to identify youth who are trafficked for sex and to assist these young people in accessing legal protections. Funding for this webinar was provided by the Novo Foundation. Points of view or opinions expressed in this presentation are those of the presenters and do not necessarily represent the official position or policies of the Novo Foundation. Today, I'm excited to introduce our faculty. We are joined by Judge Susan Briel and Professor Leslie Orloff, and I will let them tell you more about themselves.
Hello. Welcome, everyone. I'm Leslie Orloff. I run the National Immigrant Women's Advocacy Project at American University Washington College of Law. I have expertise in family law and immigration, and also benefits access for immigrant survivors of domestic violence, sexual assault, human trafficking, labor trafficking, sex trafficking, all kinds of victimization. We're really glad you've joined us here today. And I also want to let you know, those of you that either work with judges at courts or are judges who are people who are judges, we also co-coordinate with the National Council, the National Judicial Network, which is a group of judges who meet monthly for 1 hour for peer-to-peer learning opportunities around human trafficking issues and around issues that arise in cases of immigrant victims in court. At the end of the webinar, we're going to send you materials, which will include a link for judges to sign up to become members of the National Judicial Network. And we have a link also at the end of the presentation. But I won't take any more time now. We'll get into the subject matter, and I'm very happy to be here with a longtime colleague of mine who's an excellent trainer, Judge Susan Briel.
Good afternoon, everyone. I am so excited to be here today. My name is Susan Briel, and I'm a judge in the San Francisco Superior Court. I currently have a juvenile dependency assignment that I've had for about 4 years. I also handle a special calendar that involves child survivors of sex trafficking, both immigrants and non-immigrants. I also handle all U visa certification requests for the civil division of our court. And I think this type of webinar is so vital for not only us judges, but for advocates and for lawyers, because understanding legal protections for immigrant survivors of sex trafficking and the services and benefits they can access really helps them become independent from their exploiters. We're going to take a look at our learning objectives for today. And as a result of this training, hopefully by the end, you will be better able to identify immigrant child trafficking survivors who qualify for immigration relief. You will be better able to sign U and T visa certification requests in cases of trafficked children and in cases involving protective, non-abusive parents of those children. We also hope to help you issue state court findings for children who are filing for special immigrant juvenile status. So to begin with, we want to find out who has joined this webinar. Malika, if you can launch our poll. Are you a judge, a court or judicial education staff officer or member, a child protective services worker, an advocate or a child's attorney, or other? And if you're other, you can type into the chat what other is. So we'll give this a few seconds. And Malika is sharing the results. We have judges, we have court education staff. It looks like we have a lot of attorneys, children's attorneys, and we have the majority are others. So let's see, what are others? Let me look at the
We've
chat.
got, yeah,
What do we have?
attorneys that are working with children, people who work in child welfare, administrative office of the courts, a therapist,
Wow,
people working in nonprofits.
that is fantastic. We have just about everyone who works on these issues. So turning it over to you, Professor Orloff.
So let's start again to get you kind of used to, we're going to be asking you questions in the chat. So we want you to use that. And then also you can ask us questions as we go forward. We're going to start by getting a sense of what countries do the children that are victims or their parents come from that you're seeing in your courts. And I'm talking about both sex and labor trafficking, children who've suffered either or both. Anybody want to type in the chat and let us know what you're seeing in your courts? Guatemala, Mexico, Honduras, Latin American countries. Guatemala, Mexico. Judge Brill, what do you see in San Francisco?
We see everything. We see immigrants from a lot of Asian countries. We see a lot of Latin American countries. We had a need for a Punjabi interpreter on several occasions recently. So we see a lot of immigrants in San Francisco.
So, trying to get, okay. So today, about 13.7% of the US population is foreign-born. The percentage of foreign-born people who are either foreign-born, the number of people in the US who are either foreign-born or have one or more foreign-born parents is about 26%. And as you can see from this national data, that about just under 26% of all children under the age of 21 have one or more immigrant parents. So when we're talking about children who are victims of trafficking, some of those children may be citizens, may not be, but they may, even if they're citizens or lawful permanent residents, they could have parents who are non-citizens or foreign-born, which impacts, and that the forms of immigration relief we're going to be talking about today were designed to help the children themselves if they are foreign-born or undocumented, and to help their parents without regard to the child's immigration status, because the idea was for parents to be able to come forward, the non-abusive parent, to be able to come forward and offer assistance to their child. Judge Briel, why would immigration relief improve outcomes for trafficked children in state courts?
I think that there are many immigrant survivors of sex trafficking who are afraid to reach out and get help. They don't know about the benefits and services and special immigrant visas that they can get or continued presence. Some of them really want to leave an abusive situation. I had one young woman calling the court, whispering in open court because she didn't want any of the other girls or her trafficker to hear what she was saying. So I think that when immigration relief exists and immigrant survivors can access that relief, they can then feel able to assist law enforcement. They're not afraid to go to school. They're not afraid that they're going to be deported, maybe back to the country of origin, which was also an extremely abusive situation, or in some cases caused them to be kidnapped and trafficked into the United States to begin with. So there's so many reasons that their outcomes, their lives and their outcomes will improve when they get immigration relief. And I know, Professor Orloff, you did a really interesting study that was published recently that talks about outcomes and lives being improved for immigrants who can access lawful pathways to citizenship. Can you talk about that?
Yeah, I will. First, I also want to just highlight that when a victim or their parent, a child victim or their parent, begins the process of applying for legal immigration status, they get, they're more likely to use the justice system. They get access to work authorization and driver's licenses, and their access to public benefits grows. And just a small commercial here is we're doing a part 2 of this series on December 9th. We're really going to dive into the benefits and services and the full range of benefits and services that are available for child trafficking survivors and their families. And so this is the report that Judge Briel was asking me about. And it really, what we did was we looked at how gaining legal immigration status or gaining work protection from deportation, which is the first step, and work authorization transforms the lives of immigrant survivors. And what we found was 114% increase in willingness to trust the police, 36% became more willing to report future crimes to police. 22% not only helped themselves, but identified other people, other victims in the community and brought them forward to seek help. And we saw dramatic declines in immigration-related abuse from traffickers and domestic violence perpetrators, a decline in threats to snatch children, and a decline in cases where trafficking is occurring within the family and other domestic violence and other abuses occurring with the family, a big decline in efforts of the perpetrator to use immigration status to gain advantage in family court.
So going to our next poll, Malika, if you could launch this poll. Foreign-born girls are twice as likely as US-born girls to have experienced sexual assault by the time they're in high school. True or false? And
results are coming in.
So if we can take a look at our results. So we have a very smart audience here. The majority, 86% said true. And if you can talk a little bit about that, Professor Orloff, because
sure. This was this was research based on, they did a survey in Boston school systems of sexual assault, and they weren't looking necessarily for this, but what they found was that immigrant girls were twice as likely than their non-immigrant peers to have suffered sexual assault and recurring incidents of sexual assault by the time they reach high school. And obviously, sex trafficked children are part of this, but they're also children that are traumatized by sexual assault in other contexts as well. And when we look at the trafficking data nationally from the national hotline, we can see that 57% of people who call the hotline for help with trafficking are immigrants. It includes adults and minors, more adults than minors, more women than men, and that there's more calls around sex trafficking than labor trafficking, but or a combination of labor and sex trafficking.
okay, launching our next poll. For over half of sex trafficked children, a family member is involved in their trafficking. True or false? Based on all your experiences, if we can see the results coming in. Wow, 90% say true. And the answer is true.
True. 67% of sex trafficked children, one of their traffickers is a relative, is a family member, a parent, a grandparent, an aunt, an uncle, cousin, or sibling. And in 48.5% of the cases, it's a parent or a guardian. And up to 34% of sex trafficked children are trafficked by an intimate partner. So you have both intimate partners and family members involved.
You know, I was presiding over a delinquency case, and the child had a grandmother in the audience, and she was just a nice looking little old lady. And the attorney for this child asked to approach the bench and said, "Judge, that grandmother, she is her trafficker, pimp, exploiter." And I had no idea. So, you know, you would be surprised the more you handle cases like this, who is really exploiting the children that you're working with. So of course I excused her from the courtroom.
And one of the ways that traffickers, where either the child themselves is an immigrant or their protective parent is an immigrant, they will use threats of deportation as one of the powerful tools to exploit and hold the child hostage and lock them in the trafficking relationship. So it's important to be aware of that as a red flag for trafficking and abuse in these cases.
And you know, it's the threats of deportation that caused California to establish the coercive control laws around restraining orders and obtaining restraining orders. The discussion in the Senate bill for coercive control in California was precisely these immigration situations and that threats of deportation and removal.
And what we find is that perpetrators of, this is data based on perpetrators of domestic violence, sexual assault, and human trafficking. And this is looking at VAWA self-petitioners and U visas, two of the forms of relief we'll be talking about today. And what you find is that they're actively involved in trying to retaliate by getting the victim removed when she starts participating in the justice system. Whether you're talking about, you know, child welfare cases, criminal cases, family court cases, the perpetrators are very effective at trying to get the victims removed. Oops, wait. And what I wanted to, as we go through this, one of the reasons we're focusing this webinar on the forms of immigration relief available to victims has to do with the fact that the sooner you identify a child who is an immigrant, who's a victim of trafficking, and the sooner they get identified and the sooner they file an immigration case, either a T visa, contingent presence, a U visa, a VAWA self-petition, all of those cases get put in a special red flag system that basically tells immigration enforcement officers when the trafficker calls up and tries to get them arrested or stopped because of their immigration status, it tells DHS not to respond. It tells DHS that the caller is a perpetrator. And so it's the best way to protect people from removal, to identify and get their cases filed as soon as possible.
Okay, so Malika, if you can launch our next poll, we want to know, for the judges on the call, have you ever signed a U visa certification, a T visa certification, or issued special immigrant juvenile status findings? And if we could see the results. So 50% have signed one, 50% have issued SIJS findings, and very interesting and consistent with what we're seeing nationally, none have signed a T visa declaration or certification.
Is that unusual, Judge Brill?
No, no one has ever asked me in the 4 years I did delinquency, I presided over delinquency cases, or the 4 years I've handled dependency cases, I have not been asked to sign a T visa.
Yeah, and the reason for that, for people to know, is for those of you that are victim advocates and attorneys on the call, you should be asking judges. It is very a good, we're going to go over the T visa declaration. And the reason it happens is U visas, you have to get a certification in order to file. T visas, it is really helpful evidence. And so sometimes people think, oh, I'm not going to bother the judge, I don't want to ask. but it's a really good thing to do and it's something that those of you working with child trafficking victims in the child welfare system or as attorneys with child trafficking victims, you should be encouraging your judges to sign, and it's a good thing to do that helps the child's case.
Is it good, Professor Orloff, to do both, to have an attorney ask a judge to both sign a U visa certification and a T visa at the same time?
Sure, they can, absolutely. Because what happens is people can file for both, and the T visa in most states, California being one exception, the T visa gets of the child victim much more access to public benefits than the U visa. The way to kind of, as I go through this, the way to kind of think about this, I'm going to go over in a moment the various kinds of relief, but from a public benefit spectrum perspective, trafficking victims with T visas and continued presence get the most, U visa victims get the least, and the VAWA self-petitioners and SIJS kids are kind of in the middle. So there are some significant benefits to pursuing a T visa and signing both, so that the child can be in a position to win whichever case they're best suited to be able to win and get the most benefits possible.
So my sense is that attorneys think, oh, it's just too hard to get a T visa. I'll just try for the U visa for my client. But
not true. Okay. It's not harder. In fact, you can get a T visa much faster than a U visa. It seems more complicated, but if we're talking about child sex trafficking victims and their parents, there is really great documentation from the fact that they're in the court system at all that will support their immigration cases. So that these are can be very strong immigration cases. And just to let you know, the kinds of criminal activities that can serve as the basis for immigration relief is this whole list. And as you'll see, it includes trafficking, sexual abuse, sexual assault, all kinds of sex crimes. It includes child abuse, abandonment, and neglect, and all kinds of other criminal activities as well, domestic violence being a big one. And this tool that I'm going to show you next was developed by the Department of Homeland Security. It's a screening tool. We'll have it in your materials, and you can click on it, and it will take you to the DHS website for the forms. It'll most up-to-date forms, information about each of these programs. But these are the forms of immigration relief. We're not going to talk about them all today, that child sex trafficking victims and their immigrant parents that are the non-traffickers could qualify for. So a VAWA self-petition is something when the abuser is a US citizen or lawful permanent resident, spouse or parent. So let's take Judge Briel's example from a moment ago. Let's say it was mom that was sitting in the courtroom, not grandma, and she was the trafficker. In that case, if mom was a citizen or a lawful permanent resident, the child would qualify for a VAWA self-petition and a T visa. We'll be talking about U visas. We'll be talking about special immigrant juvenile status today. Continued presence we'll be talking about briefly as well, and that's something that trafficking victims can get very early on in the case. So it's as I mentioned earlier, these remedies are available both to the child and or to the protective parent. If the child is a citizen and their mom is undocumented, the mom who's helping in the case, bringing her to court, bringing her to meetings with child welfare, participating in other ways, could qualify for a T visa as the protective parent, as the parent of the citizen child. So it includes protection for parents.
So I just want to emphasize that because many of my colleagues aren't aware of the fact that an undocumented parent can qualify for protections and benefits, whether or not they were victimized, if they are non-abusive parent to the child who's been victimized.
Right. And I want to, that is a good point. When we were, and I was actually the lead advocate in the room drafting all these, this was intentional. Congress thought about, okay, if we really want to protect kids, we have to free parents to be able to come forward and participate, or guardians, or auntie, or things like that. And which form of, but it's really parents who are the only ones that actually qualify for immigration relief to help their child. if you're working with an immigrant child, an aunt can provide assistance that maybe a 4 or 5-year-old child can't. But it's the eligibility is parents and children. Judge Brill, what are the best practices that for judges in cases of immigrant commercially sex trafficked children that you want to share?
I think first and foremost, it really is to be trauma informed. And you hear that phrase a lot. It's almost trite, but it's really understanding trauma for the immigrant survivor. And trauma begins often in their country of origin, in the survivor's country of origin. Sometimes they have been sex trafficked in their country of origin, or if not, they've been abused or neglected or sent at a young age of like 12 or 14 from their country of origin to the United States. And there's a lot of trauma involved in just getting to the US. A lot of abuse that happens along the way. And then once they're in the United States, trauma can occur, especially if they're being exploited, if they're being trafficked. And then once they even get into the courtroom, understanding the trauma of the child survivor, the jangling of handcuffs by the bailiff and how that creates even further trauma, or a child waiting outside the courtroom with all that's going on outside the courtroom and the noise and the slamming of doors. So really understanding the trauma is very important. I think a judge's role is to make detailed findings about what's happening in court regarding family relationships, regarding the abuse or the abandonment or the neglect. Also, judges can play a real leadership role in setting up transnational policies between justice partners and helping to figure out who to contact, for example, in the FBI to help with continued presence. I think it's really an important role of a judge to make sure that young survivor, immigrant survivor, gets an immigration attorney. And our role really is to appoint an immigration attorney if need be, if they are not able to access an immigration advocate or attorney on their own. Let's see, did we get them all here? Here's a whole list of best practices for child welfare agencies. I think that referring survivors to programs that help immigrants is really important. And Professor Orloff has a whole directory on places to refer survivors. Not be afraid to sign U&T visa certification requests, and child welfare officers can and should be signing these U visa certification requests. And also make sure that whatever decisions are being made by child welfare agencies and prosecutors' offices don't have unintended consequences for immigrant child survivors. For example, if a recommendation is to reunify a child with abusive parents, that's really going to affect their ability to get special immigrant juvenile status. So there can be unintended consequences to decisions that child welfare agencies sometimes make, or prosecuting agencies. We're going to now talk about forms of immigration relief for child trafficking victims, and we'll start with the T visa.
So the T visa is it's for victims of severe forms of human trafficking, either sex or labor trafficking, and it's for both adult and child victims. Children who are victims of sex trafficking under the age of 18 don't have to show force, fraud, or coercion. Labor trafficking victims do. They have to be physically present in the United States on account of trafficking. And people often confuse this. They think the trafficker had to bring them over the border. That's not true. The trafficker had to control their movement, their choice, their ability. If they held them hostage, I mean, there's a variety of different ways that somebody could get here who's an immigrant and then be trafficked. and that they need to show, they usually, they need to comply with reasonable requests for prosecution unless they're under, with prosecution investigation. But children under the age of 18 are exempted from that, as are adults who've suffered psychological trauma. And this T visa, the timeline to work authorization is about 12 to 24 months at this point, 12 to 18 months. And the judicial role here is signing the T visa declarations and making good findings about the trafficking and about the relationships, like Judge Brill was talking about. And we have a resource for you that will be in the materials on this point.
So U visas is a pathway to lawful immigration status. And the first step for a survivor of sex trafficking to get a U visa is to get a certification request signed by those authorized to sign them. Judges are one of the officials that can sign a U visa certification request. And in order to get the signature, the victim has to be a victim of certain qualifying criminal activity. And there's a whole host of crimes, and we'll show you the list. There's like about 50 crimes, plus any attempts to commit those crimes, plus any related crimes to those crimes are qualifying crimes. And then the victim has to either be or likely to be helpful or has been helpful in the detection, investigation, prosecution, conviction, or sentencing of a case. The victim has to have suffered substantial physical or mental abuse as a result of the victimization, although this is not a finding that a judge needs to make or a social worker, someone authorized to sign the U visa certification request. That finding is left up to USCIS at a later time. The victim just has to have possess information, have information about the crime, and the crime has to have occurred in the United States. So another form of relief, immigration relief, is a special immigrant juvenile status, SIJS, which is immigration relief for an unmarried child. The child has to be under the age of majority in your state. So the age of majority in California is 21, and I think Mississippi and Missouri might have the age of majority as 21, but many states have the age of majority as 18. So you have to have jurisdiction over the child, and you have to be aware of what the age of majority is. The child has to have filed the SIJS petition before the age of 21. And the victim of abuse, the child has to be a victim of abuse, abandonment, or neglect by one or both parents, but it can be just one parent. So if you have a parent that you're returning the child to as a judge, you're returning the child to the mother, but they were abused by their father, then they would still qualify for special immigrant juvenile status. And so a court has to have jurisdiction over the placement of the child. So often that would be dependency court or family court or delinquency court. And then, of course, moving on to VAWA self-petitions, Professor Orloff.
Yeah, and so, you know, what's interesting about SIJ is a child who's abused, abandoned, or neglected by their parent anywhere in the world qualifies for special immigrant juvenile status. Could have happened in the US, it could have happened abroad, doesn't matter. VAWA self-petition will always be it will be always a domestic violence case or a child abuse case where the perpetrator is the US citizen or lawful permanent resident, spouse, or parent. And so those will be there'll be cases where if you have a US citizen or lawful permanent resident, spouse, or parent, and there's child abuse, and the trafficking, and maybe that parent is involved in the trafficking, or, you know, may or may not be involved in the trafficking, but this is a path for children who've been abused, who are victims of child abuse. And now we're going to show you kind of how easy it is to see give you a scenario so that you can see how to identify who qualifies, what children or adults qualify for, and their parents qualify for these kinds of immigration relief.
So here's our scenario. Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara. She was raising her 12-year-old daughter, Juanita, and Juanita's father abandoned Juanita when she was an infant. After becoming pregnant, Clara gave birth to a baby girl, Lupe. So Eduardo decides to bring Clara, Juanita, and Lupe to the United States to live with him. And when they arrive in the US, Eduardo takes Clara, Juanita, and Lupe's El Salvadorian passports, and he becomes physically and sexually abusive to Clara. Within a year following their arrival in the United States, Eduardo forces both Clara and Juanita to work for the family's business and never pays them for their labor. One night, when Juanita was 14 and Lupe was only 2, Eduardo flew into a rage and beat Juanita and Lupe severely with a belt. When Clara intervened to protect her children, Eduardo strangled Clara until she passed out. The neighbors call the police for help, and Clara talks to the police when they arrive. The police arrest Eduardo for attempted murder and sexual assault of Clara, and for child abuse and aggravated assault of both Lupe and Juanita. The police take Clara to the hospital, and the children are placed in foster care. So Clara, our next part of the scenario is that Eduardo is convicted of sexual assault and attempted murder of Clara in criminal court, and of child abuse and aggravated assault of both children. He's sentenced to a long prison term. Lupe and Juanita's neglect cases are assigned to Judge Breslow, and both children are adjudicated neglected children. Judge Breslow grants Clara's request for sole legal and sole physical custody of the 2 children and continues the case for monitoring. Juanita then runs away from home, and she's taken in by friends who actually end up trafficking her, forcing Juanita to engage in sex with men in exchange for money. After being in runaway status for a year, Juanita returns to her mother. And so our polling question for everyone is, what forms of immigration relief would Clara, first of all, qualify for? And if we could launch our poll, would it be a U visa, a VAWA self-petition, or a T visa? So Malika, you can launch our poll and check all that apply. You can check all that apply. Maybe all 3, maybe 1, maybe 2. No hints. And now, if we can see our results.
Yep. So 82% are saying U visa, 59% are saying VAWA self-petition, and 41% are saying T visa. The answer is.
So let me guess. Okay. Professor Orloff, I think it wouldn't be a VAWA self-petition because Clara was not actually married to Eduardo.
Exactly.
Yes.
Right. And why would it be a T visa?
Well, because she is a victim of trafficking, of labor trafficking, when she's forced to work for Eduardo. But I think we're going to talk about that a little more.
Yeah, exactly. And then she's a U visa victim because of all the crimes that she's.
Right. Those are qualifying crimes, and we'll talk about the qualifying crimes for a U visa.
Go on to the next one.
All right. Our next poll is what forms of immigration relief would Juanita qualify for? If we could launch that poll, would it be a VAWA self-petition for Juanita, a U visa, continued presence, so she can stay in the US, special immigrant juvenile status, or a T visa? lots of choices. And you can check more than one.
Okay, some more of you want to vote? We'll give you a little more time. This one you have to think about a little. 36%, almost 40. Shall we discuss this?
All right, so let's see our results. Okay, VAWA self-petition, only 12 people chose that. And U visa, more people, continued presence, a little less. Everyone chose special, most everyone, SIJS and T visa. So
So what-
whoever did not choose
Okay,
VAWA
so,
self-petition, I would not have chosen VAWA self-petition.
right, exactly. She can't file a self-petition because Eduardo, who abused her, was not her father or stepfather. There was no marriage. If there was a marriage, then she would be eligible to self-petition as well. What's really interesting,
Because her biological father, remember from the hypo, he abandoned her.
and that's the basis she has for special immigrant juvenile status. Because because there was no marriage, she can't have special immigrant juvenile status based on Eduardo's treatment of her. She gets special immigrant juvenile status based on abandonment by her biological father. If there was a marriage, she could have special immigrant juvenile status based on him.
And then she would qualify for a U visa because she's a victim of all those crimes perpetrated on her by Eduardo.
And she qualifies for T visa and continued presence because of both the labor trafficking and the sex trafficking.
Yes.
So she's a victim of labor trafficking for Eduardo and sex trafficking later on. They both qualify her for both T visa and continued presence.
Yes.
Okay, let's go to the next one.
Okay, this one's a little tricky, our next question. What forms of immigration relief would Lupe not qualify for? Not in full caps. And you can choose more than one. Would she not qualify for a VAWA self-petition? Not qualify for a U visa? Not qualify for a T visa? Or not qualify for SIJS?
You guys can guess if you'd like.
Are they guessing?
Yeah, we're up to about 32%. I think that's good. So you want to show us up to 39, 41, there we go. Okay. So the one that, so.
No one chose.
Everybody understands that she qualifies for the U visa. That's correct. Does she qualify for SIJS?
I would say yes.
Yes, because Eduardo is her biological father.
Right.
So without regard to any marriage, she qualifies for SIJS.
And he abused her. He beat her.
And he beat her. And he's a lawful permanent resident and she's his child. So she also, as you all see here correctly, qualifies for a VAWA self-petition. She qualifies for a U visa. She does not qualify for a T visa by herself because she wasn't trafficked. She's the younger daughter.
Right. She wasn't a victim of either sex trafficking or labor trafficking. She's
a
2-year-old.
Right. But those of you who chose this might know that if Clara files for trafficking, the T visa, she can include her daughter. And if Juanita files for trafficking T visa, she can include her sister.
Oh, so they might have been thinking that way.
They might have been thinking that, but she doesn't herself qualify directly, but that's how it works. So we're going to go to the next slide. Thank you, Malika, for that. And what I want to basically say at this point, the other thing when we're talking about child sex trafficking victims and child welfare cases and all kinds of family law cases is the newest enforcement priorities that were issued September 30th that went into effect November 29th of 2021. The only people that are at risk for removal are the people who are threats to border security terrorism, or public safety, provided they don't have mitigating factors. Many of the child trafficking victims that you encounter will not fall into this group, these priorities. For example, child adjudications in child delinquency cases do not count as criminal convictions under immigration law. And so there are some exceptions to that, not so much convictions. Drugs and gangs are particularly problematic. But generally speaking, most people, the way these priorities work is if somebody's undocumented, the only time there's a danger of their removal is if they're an enforcement priority. And even people who are enforcement priorities, will not be removed if they have mitigating factors. And in all of these cases, the victimization, being a trafficking victim, being a child abuse victim, are all and being eligible for VAWA T or U visa or SIJS immigration relief, which are considered humanitarian forms of relief. If somebody has a criminal history, or entered the country after November 1st, 2020, and they are high priority, they will not be removed if they, in fact, are a victim of these kinds of crimes.
But the other exception besides gangs and drugs for children in the delinquency system is prostitution. And there are still states around our country where, children who are survivors of sex trafficking are charged with prostitution, even though, they haven't learned from the National Council of Juvenile Family Court Judges that there's no such thing as a child prostitute. That's our motto at NCJFCJ. So if you have a case and the child is charged with prostitution, that can be really dire for that child, even as a juvenile.
Exactly. And so one of the things that we wanted you to understand is when you look at the federal definition, and many state definitions track this, of sex trafficking, it has three parts. You have to have a process or an act of trafficking, of recruitment, of soliciting, or benefiting financially from the process or the act, harboring, recruitment, etc. Then you have to have force, fraud, or coercion, unless it's a child. So anytime you have a sex trafficked child, you don't have to worry about the means. It's if in fact there has been trafficking and they've transported or obtained them, provide, patronized, solicit them, gotten them involved in trafficking, and they're under 18, then the next question is, was the end or purpose of this commercial sexual activity, and that, or something of value? And that includes, a lot of times kids are given by their traffickers money or drugs or food or shelter or clothing or transportation. All of those are things that are the equivalent of money, I guess you could say, when you're thinking about the definition, whether they fit within the definition of trafficking. For labor trafficking, it's similar. You have the same process questions, but the process could be the person is trying to benefit financially or get something of value from the labor. So if we go back to the scenario, his family business didn't have to pay a worker because they were able to force Clara and Juanita to work. And here, though, for Juanita to prove that she's a labor trafficking victim, she will have to show how Eduardo coerced her. Wouldn't be that difficult. There's some good laws on the books on this that I'll be showing you later in terms of new policies from DHS, but that's how that works. And then the purpose here of the labor trafficking has to be involuntary servitude, peonage, debt bondage, or slavery. And so this is some more information about force, fraud, and coercion. But again, in child sex trafficking cases, generally, they don't have to prove that. And but in labor trafficking cases, they do. And these slides are here for your reference for later.
So our next poll, and Malika, if you could launch our poll, which of the following could be a process through which a trafficker picks their victim? A dating app, international marriage broker, guardianship of a minor, trafficker, locks the victim in the house or workplace, all of the above. This one's pretty easy.
Okay, we're at 50%. That's great. Share the results.
Correcto mundo, as we say in Latin, all of the above.
Exactly. Oops, sorry, I gotta change my slide here.
So remember that trafficking does not require the crossing of a border. You may have a child immigrant survivor of sex trafficking who wasn't trafficked till they got to the United States. And the recruitment can often happen through a dating app, through adoption, believe it or not, or guardianship or marriage, the promise of housing, the promise of shelter or a better life. Victims are often isolated. They're sometimes locked in, made financially dependent and emotionally dependent. And there's a lot of ways of accessing victims. There's boyfriending, pretending to have a romantic relationship with the victim, telling them they'll take them to parties, they'll take them places, buying them a new phone, buying them makeup, grooming them. They access victims through social media. Hey, saw your picture, you look hot, let's go on a date. And they start a conversation that way, or sometimes face-to-face. Malls are a great place for traffickers, exploiters, pimp exploiters to recruit children, bus stops, bus stations, even schools, or kids hitchhiking alone. So there's a lot of ways they can access victims.
And that the forced fraud or coercion can also happen a lot of different ways. You can have threats of physical or actual physical or sexual abuse. You can have threats of deportation, to take or destroy passports, immigration papers, IDs, cutting might be a young victim who has a child, cutting the victim off from her child, making her homeless, depriving them of food. All these different ways can be part of the forced fraud or coercion, where as a trafficker, the goal is to get the victim to stay and to rob the victim of the choice to either leave or do, not do what you're asking them to do.
So I know that we're focusing mostly on sex trafficking, but one can be forced to work by a spouse or an intimate partner or parent constitute labor trafficking. And I think, Professor Orloff, there's some new policies by USCIS.
Exactly. So there's a new policy manual was issued by the Department of Homeland Security that's in your materials that we'll be providing you. And they have very good guidance on this, as they basically say that where the condition of involuntary servitude is induced by a scheme or a plan, that somebody would suffer serious harm, be restrained physically. And this can happen. They recognize that this can happen in intimate partner relationships and parent-child relationships, that the trafficker could be a roommate. In the case of Juanita, it was her mother's boyfriend. It doesn't matter, that you can have trafficking in those situations where it's part of the pattern of child abuse, for example. But that, and the threats can come and be physical, emotional, intimidation or coercive control, and that domestic labor can also constitute involuntary servitude in certain circumstances. And so it's just important to understand that the fact that the labor trafficking was forced by her mother's boyfriend doesn't mean, or that, both for Clara and Juanita, that it doesn't mean that the trafficking didn't occur.
I think that trafficking in many ways is like domestic violence or intimate partner violence. And we know from years of experience that victims of domestic violence do not want to, many of them don't want to participate in the prosecution of a case. They don't necessarily want to come to court and talk about the abuser. And, much like domestic violence, the young women in my enhanced calendar who are survivors of sex trafficking, they're not about to finger their trafficker. I would never ask them the name of their exploiter. And I'm wondering if, the fact that Juanita ran away from home and she's not willing to name her trafficker or cooperate with the police inspector, would that affect her ability to get a T visa, or is there some trauma exception you can talk about?
There is an exception. So the cooperation, so we were talking earlier about how there was a difference between sex trafficking and labor trafficking in terms of whether children need to prove force, fraud, or coercion. There is no difference between sex and labor trafficking when it comes to having to cooperate in the investigation or prosecution of their traffickers. Children are outright exempt. Under 18-year-olds do not have to cooperate to obtain immigration relief through the T visa, continued presence, or continued presence. They're exempt. So Judge Briel, could keeping a non-citizen sex trafficked child in custody have unintended consequences?
I think there are enormous unintended consequences to keeping a sex trafficked child in custody. Imprisoning them, maybe the judge thinks it's for their own good or their best interest. But there is the Juvenile Justice Reform Act. Remember that? Juvenile Justice Reform Act that really mandates that state facilities screen youth and divert them to alternative programs and services other than jail. Children have been often imprisoned by their exploiter, and to re-traumatize them by keeping them in custody just makes it honestly worse for a child survivor to heal. I think a lot of law enforcement officials and judges think, well, if I don't keep this victim of sex trafficking in custody, they're just going to run. They're an immigrant, they're just going to run. And really, if a child's going to run, a child's going to run, but the child is not going to run because of their immigration status. And it's really a myth or a misconception some of my colleagues have that it's their undocumented status that makes them a flight risk. There's an important case, it's a federal case, it's Lopez Valenzuela versus Apayo. It's 770 F 3rd 772. And the quote that's important from that case says that there is no evidence that undocumented status correlates with a flight risk. So first of all, a child survivor of sex trafficking is not going to run just because they are undocumented. But second of all, it is extremely harsh to re-traumatize a child who's already been so traumatized by the time they come before a delinquency judge or a dependency judge.
So rather than, one of the ways a judge can help a child is by offering to sign a T visa declaration.
And what do you need? What information do you need, Professor Orloff? What's in the declaration?
So the declaration will ask the judge to identify the kind of trafficking it was. So sex trafficking, child sex trafficking, labor trafficking. Judges make findings all the time. So you take the findings that you're making in your state court case and you're describing the victimization. So the lots of times a judge, if you made your findings in an order, then you can attach your order in which you describe the victimization. You identify if there's a relationship between what relationship between the crime you detected and what's being prosecuted or investigated. So again, if you've got a child, and the prosecution or investigation could happen in a criminal case, could be a child welfare investigation. It could be, it could be something that the police are looking into that aren't, the child's in a dependency proceeding, but it's not, but there doesn't have to be an open criminal case. They could have reported it. It could be in process, but they could be at different levels. And then you can also talk about if you often might see evidence of retaliation or revenge. anything you know about that you could put in the declaration is helpful. The dates of the trafficking, really important to put statutory sites in the declarations, because if you think about this, the adjudicators that are handling all these cases are seeing 52 different jurisdictions. And so they don't know what the citations are, and you don't want them to try to figure out what your state law is. And then information, any other information there might be about the traffickers and any family relationship that there might be, you know, they turn to the courts and these declarations as helpful in providing information about whether family members are traffickers.
So we talked a little bit about the fact that judges like me aren't seeing requests for T visa certification. I'm wondering your opinion on that, and to explore it a little bit further with you. Do you think it's because, you know, there's no statute of limitations for signing a U visa certification? Is there a statute of limitations for a T visa?
No statute of limitations for a T visa. I think some of it has to do is because the bar, the people that represent victims doing trafficking cases, are not used to being in family court, for example. And so I think because they're not required to go get a certification, they don't. But that doesn't mean that those of us that are working in the family courts with trafficking victims couldn't initiate the process or, you know, offer to help, because we're there and we can ask the judges. So it's something I just think that people haven't done enough of, that I know the Department of Homeland Security would like to see more people doing. And I think it's a role judges can actively play, just as they can play a role in initiating a process of getting a child to continued presence. So continued presence is the first form of immigration relief that's available to a T visa victim, a victim of sex trafficking, child sex trafficking. And it's any victim of child sex trafficking who may be a potential witness in a sex or labor trafficking investigation. And so anytime you have an immigrant child sex trafficking victim, one of the challenges, I think, for the court, for the judges, and for all of us working with that sex trafficking victim is identifying, you know, working with your state and local law enforcement to identify and get this case to, because the state and local law enforcement agencies can request that FBI and or other federal agency, EEOC, if it's a labor trafficking case, and then at the Department of Homeland Security, there's an agency called Homeland Security Investigations, and they can file the request for file the official request for continued presence for child trafficking victims. And judges can play a leadership role, like now in the teams that in the work that you're doing locally, to say, if this comes into my courtroom, how am I going to make it happen? Who do I need to call, and who can collaborate, who I can refer it to, so that there are people in my community that will take these continued presence requests forward. Because I'm telling you, this very few child trafficking victims are getting continued presence. And it's not because the cases are denied. It's because people haven't figured out how they're going to work that system when they have a trafficking victim who needs that help. And that's a big role that people on this webinar can play in making happen. And there's a very good resource guide, a new one in the materials we gave you, that came out in July from the Department of Homeland Security that helps you walk through how to do that.
You know, I have to say, I was so impressed with this attorney who came before me recently, because I asked her on a immigrant child sex trafficking case, have you started the process for immigration relief for your client? And she said, we're working on continued presence, we're working on a T visa, we're working on a U visa, we're working on special immigrant juvenile status. I've contacted the FBI. And I actually told her in court today how impressed I was with that, because I found it very unusual that she was seeking every avenue of immigration relief, including continued presence, including contacting the FBI to help with that.
That's great. And for those of you on the call, have you, like, what kinds of federal agencies do you have relationships with in your community that you might be able to reach out to, who could sign continued presence requests. And this gives you a list of some of those agencies that you could turn to. Anyone want to share some of those agencies you may have worked with? Type it in the chat. I know you guys have been really good on the multiple choice questions. Let's see if we can have some of you participate in the chat.
You know, Arizona, that hasn't always been so great on immigration policy, has the state of Arizona has a transnational toolkit that that also brings together different agencies to collaborate on policies for non-citizen trafficked youth. So there's things that everyone participating on this webinar can do to take leadership roles to figure out who should be on their task force, to form a task force, to figure out who would be the person to go to for continued presence and for a lot of the other forms of relief. We're going to transition now to U visas to promote trust and access to justice. And immigration relief is available for victims of all of the crimes that you see listed in this slide, but not just these crimes, but for any attempts or related crimes. You can get U visa for any of these crimes. And if you look at this list, rape is one of the crimes. And of course, Clara was a victim of rape. You can get a U visa if you are a victim of trafficking and you see trafficking as a crime there. But also, you know, related crimes. Juanita was beaten up pretty severely by Eduardo, and there is assault as one of the crimes listed, felonious assault. Certainly, if you're a victim of rape, sometimes you're also a victim of false imprisonment, and you see that as one of the crimes listed. Also, obstruction of justice is an interesting crime. That's one of the numerous crimes to get a U visa, and just threatening to have a child or an intimate partner deported is, if they report the crime, is obstruction of justice. So those are the crimes that allow for immigration relief in the form of a U visa.
And if I can just say something, for those of you that are working with immigrant children who may qualify, or their parents who qualify these forms of relief, it's really important in the case to identify any one of these that's occurring. So you could have, you know, you could have extortion. Maybe, you know, you have a child who's working and has to turn over their salary to their trafficker, or, you know, all of those kinds of things that you want to check all of them that you identified, and that when they sign the certification, you want to check everyone that exists in the case. It's not about which one, if any, are being prosecuted. So it's important to understand that.
So remember, you can sign a U visa certification request if you detect any criminal activity. And if the victim is helpful, was helpful, or will be helpful in the detection, investigation, prosecution, conviction, sentencing of a criminal case. But what is helpful? And helpful is giving any credible evidence, and that's a really important, almost a probable cause standard. And helpfulness can be detected in all these different arenas, in a civil protection order, in a custody case, a divorce case, when a victim comes forward and says that she's been beaten or he's been beaten, in an adoption case or a conservatorship. All of these courts are avenues for detecting helpfulness. Even if you have a landlord-tenant case and a victim says, he's trying to evict me and says he'll have me deported because I said I would report the sexual abuse to the police. So suddenly you find helpfulness in an arena you wouldn't normally find helpfulness, which is in a landlord-tenant case. So criminal activity is detected in all sorts of ways. and all sorts of avenues. And it's
And
any
these-
credible evidence.
And just like you could find trafficking in any one of these cases as well.
So again, we have a poll here. Why would victims seek U visa certification from state courts?
Letters in, or all of, which letter you choose in the chat.
Or a judge observed the victim's attendance and participation in a criminal case? All of the above.
Okay.
So we have from John Hudson, from Dee Dee Connor,
We have a couple
everyone.
of people who are putting D in the chat.
D. Absolutely, it's D. So
Yeah.
often it's the only justice contact a survivor has had. Suppose a child sex trafficking survivor has healed enough to try to get a restraining order. And finally gets an immigration lawyer. So comes to your dependency court for the first time ever and asks for a restraining order. So that's the first contact. And sometimes the first contact to get a U visa is a court you wouldn't ordinarily think of as a place to be helpful and give information. You would think it was criminal court.
Mhm.
So who can who can sign off on a U visa certification? Judges, magistrates, commissioners, referees, all of these judicial officers or others delegated to decision-making authority. And also sheriffs, federal or state departments of labor can sign off, state police, the FBI, prosecutors, and child welfare workers. I don't often see child welfare workers signing U visa certification requests. I know we have people from child welfare on this webinar, and I think it's just really a training issue. But certainly, sometimes the first point of contact for a child survivor of sex trafficking is with the child welfare worker. And they can certainly sign a U visa certification request. So this is what the certification form looks like. And judges and other officials can feel free to cross out what they feel doesn't apply on the certification form. For example, it often says, based on my investigation. Well, judges don't investigate cases, but we often hear testimony, and you could say based on the testimony, or based on the sworn testimony that I heard, or the sworn credible testimony. So you can cross out investigation and based on the probable cause finding I've made, based on the protective order I issued, and you can place that right in the certification form. And remember, we as judges, as law enforcement officials, or child protective services workers, we're not certifying that the applicant should be a US citizen or that the applicant should be a lawful permanent resident. All we are certifying is that they have been helpful in the detection or the investigation or prosecution or conviction or sentencing of a particular qualifying crime. If you've detected that criminal activity, that's good enough. So what helpfulness do judges see? Judges often see helpfulness of an applicant in the pleadings themselves or in the testimony, in the fact that they've come to court. And some judges, like me, ask people in court a lot of questions to get, clarifying information. And if I have an individual who's answering my questions and then giving me information that I realize makes them qualified for a U visa, possibly. Of course, I'm just a judge. I'm not an expert immigration lawyer. But if I hear helpful information, then I can put that in the U visa certification request.
Yeah, and there's different kinds. We have some slides here that you can use like as checklists of the kinds of things that come up in family law cases, the kinds of things that come up in criminal court cases. And that it's important to know that, the certification can be completed as soon as the judge rules on something. So they could issue a protection order, or they could place the child with somebody in temporary orders in a child welfare case, or anytime, generally judges, although they can legally certify based on what may happen in the future. Generally, judicial certifications are based on what's already happened. Mom has been bringing the child to court, and they're certifying for mom's U visa application. And the case can still be ongoing. There may never be a criminal case. There's all of these different, it's a very much of a victim-centered approach and a victim-centered tool.
So since there's no statute of limitations, you may have a child survivor of sex trafficking who's an immigrant who finally gets their lawful permanent residency. Maybe it's like 6 years later, and comes and asks for you to sign a U visa certification request. You can sign it if you have information that, 5, 6 years ago, they asked for a restraining order, or if they were helpful in some way. So why would the timing of the certification be important, Professor Orloff? I'm assuming that maybe someone's in removal proceedings, but what do you think?
That's certainly one reason. I mean, when somebody's in removal proceedings, moving as quickly as possible is important. But actually, because of what's called, VAWA confidentiality, Violence Against Women Act confidentiality, which is an form of immigration protection, that child trafficking victims and their parents who apply for these forms of immigration relief get. But that system of offering that protection, which is a form of protection from deportation, doesn't work until they file their immigration case. So if you delay certification or findings, as we're going to talk about in a minute, in a special immigrant juvenile status case, if you delay the process, then the victim's case is not in the system, so that if the trafficker is trying to get her deported or get mom deported in retaliation, DHS doesn't know that she's a victim and could respond to the do the trafficker's bidding. And so it's better for everybody, for DHS not to waste its resources and to protect victims, to identify these cases and file as soon as possible, whether or not somebody's in removal proceedings.
So then a best practice would be to sign the U visa certification as quickly as possible. And I also think a best practice is to list all the qualifying crimes in the application, because USCIS, who knows what they might hang their hat on. They might want, like, the rape charge of Clara better than the labor trafficking charge you put in the U visa application, or the attempted murder charge, all of which qualifies her for a U visa.
Exactly. And the other thing is the victim has to show substantial harm to them when they prove it to DHS from one of the checked off boxes. And it's easier to prove substantial harm from sex trafficking, from the sexual assault, than from labor trafficking, for example. It's not impossible, but it's much easier because they can line up with any of those elements. Shall we move to special immigrant juvenile status?
Right. So special immigrant juvenile status is a humanitarian form of relief for unmarried children who can't reunify with one or both parents. But again, it only needs to be one, who the child has to have been abused, abandoned, or neglected. And state courts have to make these prerequisite findings of abuse, abandonment, or neglect. And Congress felt that judges were in a very special position to make these findings, and findings about whether the child should be returned to the parent or not returned to the parent, because us judges make these findings anyway. We make them every day, whether it's an immigrant survivor of sex trafficking, or it's an immigrant or a non-immigrant. We make these findings in dependency court. And so those are the findings we make. And we have to we have to be in a court, whether it's delinquency or dependency or family court, that issues orders regarding the placement of children. So criminal court doesn't count. And we have to make findings that it is not in the child's best interest to be returned to their country of origin, and that reunification is not viable with one or both parents. I've had attorneys, believe it or not, argue with me, well, the child hasn't been abused, abandoned, or neglected in Guatemala. The child was just sent across the border to the United States for a better life. Actually, that is abuse and neglect of a 12 or 14-year-old child. And I think there's some case law on it that Professor Orloff, you may have in your resource materials.
I actually don't. That one I don't.
Okay, well,
I'm not sure there's case law on it, but I think, you know, it all, and the reason is it turns on the interpretation of abuse, abandonment, and neglect, how it's defined in each state's law. So you're going to use your state law to apply to the facts to determine whether, if that happened to a child based on California law in your case, whether it would be abuse, abandonment, or neglect.
well, I made a long finding. We actually had a hearing, and I think a best practice for SIJS is to have a hearing. I've been convinced by my colleagues at the National Judicial Network to hold actual hearings on this. And I made a long finding that, yes, it's neglect of a 14-year-old to send them by themselves across a border, you know, and it was abuse. And in fact, a lot of terrible things happened to the child before they ever even got to the United States, once they were abandoned and left to fend on their own.
Exactly. And so that's the first, there's three things that a court has to find. You have to find that there was, you know, that you have to place the child, and then you have to find that it's not in the child's best interest to go to the home country, to be returned to their home country. And a lot of times people focus on gangs and drugs and all of that kind of stuff, which may be helpful, but most of the inquiry, if you think of a child trafficking case, you could have a case of a child who fled to the United States, came to the United States to reunite with her mother, and she came here, let's say, to reunite with her mother, and her mother is living with a new husband and his three brothers. And she fled home because her biological father sexually assaulted her. And he sexually assaulted her in grandma's house. And so in a case like that, as the court in a dependency or delinquency or a child custody case or a child protection order case or something, is looking at where it's who, you know, with whom is it in the child's best interest to place the child? You can't place them with dad, and you have to look at who your state laws require you serve in the kind of case you're doing. So, you know, in this case, the child was abused in her home country by dad and grandma's house. So there's nobody in the home country of those, neither of those could be good custodians, but she could be with biological mom or aunt or grandma safely in the United States. And so once you make that placement, you've proven that there's no place in there, it's not in the child's best interest in the home country to return to the home country, because there isn't a qualified person who can care for them under the state laws under your best interests. And then once you've eliminated placements, and you don't have to go find every placement possible, you've eliminated the placements that you'd normally look to, both parents and things like that, in a child welfare case or a child custody case. It's then, once you've decided which parent has abused, abandoned, or neglected the child, the question is whether reunification is viable with that parent. And if you've decided not to give them full custody at this point, you can make the finding that reunification is not viable, even though that parent may have ongoing contact, let's say through supervised visitation or something with the child.
You know, it's very important to look at best interest of the child, not to return to their country of origin, and not get confused the way a judge did in the Leslie H. case, which is a very famous California case, where the judge said, well, it's not in this child's best interest to stay in this country. She keeps committing crimes. She's robbing liquor stores. She's getting in trouble here. But the truth is, that wasn't the standard. You have to look at whether it was her best interest to go back home to her country of origin where her mother was tying her up with chains and starving her. So it's really a best practice not to consider the motive of whether, and the judge said, oh, she just wants to be a US citizen. We cannot consider motive of the applicant for SIJS. We just really have to follow the laws and procedures outlined.
So Judge Briel, are there unintended consequences of reunification services with SIJS children?
Well,
children?
I think we talked about it a little bit, that it has to be not in the best interest of the child to return to one or both parents. So if you're giving reunification services and trying to reunify the child with the parents, and say the parents are here in the United States or even outside the United States, then it's going to affect the SIJS application.
So the same jurisdictional rules and the same laws apply in cases where you're issuing SIJS findings as, your delinquency or dependency cases. We have a really nifty tool in the materials we're offering you where you can look up by proceeding across states. You can see what other states are doing, and within your state, what the service of process and jurisdiction and the ways you can find alternative service if you need in one of these cases of a child trafficking victim to serve a parent who lives abroad. And so we have this tool for you. What do you want to be sure to include in SIJS findings, Judge Briel?
You want to make sure you put what the abuse is according to your state statute. And you want to be very particular about that, or whether there's abandonment or neglect and how that's codified in your state. And I think you do a best practice is to hold a hearing. And as I said, not consider the motive of the person seeking SIJS status. Handle the case the way you would handle any child case in your dependency court, whether they're, what is in the best interest of the child to where they should be placed, whether there was abuse, abandonment, and neglect.
So we've given you here today an overview of the types of immigration relief that a child sex trafficking victim or a child labor trafficking victim could qualify for. And we've reminded you that not only could they qualify, but you might have child sex or labor trafficking victims whose parent is the one who's the undocumented immigrant. And those parents can apply for all of these forms of immigration relief in order to protect their child that we've been talking about today. We have a website available that we are going to post the slides from this, the video from today, and all of the materials for you. And we also, in closing, want to remind those of you that are judicial officers and those of you that work with judges in your court systems around the country to share information about the National Judicial Network with judges you work with, where they can get ongoing continuing education and learn from other judges around the country who are seeing child sex trafficking victims in their courts and other child trafficking victims.